Judgment in the matter of the Queen on the application of Derry versus Commissioners for Her Majesty's Revenue and Customs.
In November 2010, Mr. Derry sold a shareholding at a loss. He claimed tax relief for the loss under Section 132 of the Income Taxes Act 2007 in the self-assessment tax return which he submitted for the previous tax year, and paid tax on his income for that year on the basis that he was entitled to claim the relief. When he submitted his tax return for the following tax year, he explained that relief for the loss incurred during that year had already been claimed and obtained in respect of the previous year. In response, Her Majesty's Revenue and Customs, HMRC, opened an inquiry into his claim for relief in the previous year's return under Schedule 1A of the Taxes Management Act 1970, which only applies to claims which are made outside of a return. They were unable to open an inquiry under Section 9A of the 1970 Act, which applies to self-assessment returns, as the statutory time limit for doing so had expired. They subsequently issued a demand for tax on the basis that Mr. Derry had not been entitled to claim the relief in relation to the tax year preceding the year in which the loss was sustained. Mr. Derry challenged the demand in proceedings for judicial review. Two issues were raised in those proceedings. The first was whether Mr. Derry was entitled to deduct the loss in calculating his net income for the previous year, or whether, as HMRC contend, the effect of Schedule 1B of the 1970 Act was that the loss could only be claimed in relation to the tax year during which it was sustained. The second issue was whether, even if Mr. Derry had been wrong to claim the relief in relation to the previous tax year, the claim nevertheless formed part of his self-assessment tax return for that year, in which event HMRC had failed to open an inquiry into the return within the statutory time limit. Mr. Derry failed on both issues in the upper tribunal. On appeal, the Court of Appeal found in favour of HMRC on the first issue, but in favour of Mr. Derry on the second issue. In other words, it found that Mr. Derry had not been entitled to deduct the loss when calculating his net income for the previous tax year, but that his claim for relief nevertheless formed part of his tax return for that year. As HMRC had failed to open an inquiry into the return within the statutory time limit, Mr. Derry's challenge to the tax demand succeeded. HMRC now appealed to the Supreme Court. The Supreme Court unanimously dismisses the appeal, finding in favour of Mr. Derry on the first issue, and not finding it necessary to decide the second issue. On the first issue, whether the loss was correctly deducted from the net income for the previous tax year, the Court considers that Sections 23 and 131 to 132 of the 2007 Act create a self-contained code for the treatment of a claim to share loss relief. Sections 132 and 133 give Mr. Derry an entitlement to make the claim, to specify the tax year to which it is to be applied, and to do so by deducting it in the calculation of his net income for that year. In the Court's view, it would be extraordinary for that entitlement to be taken away without any direct reference or signpost by a provision in a schedule of another statute, namely Schedule 1B of the 1970 Act, which is concerned principally not with tax liability, but with the management of tax. Other provisions of the 2007 Act concerned with other forms of relief refer expressly to Schedule 1 of the 1970 Act, but no such words are present in the provision concerned with share loss relief. The absence of such words in that provision indicates that this right is not subject to the same qualification. On the second issue, whether if Mr. Derry's claim for loss relief had been made in error, it would nevertheless form part of the tax return, it's unnecessary for the Court to reach a conclusion. In addition, the Court is not satisfied that the issues were fully explored in argument. There remain uncertainties as to the correct interpretation of the entries in the online self-assessment form and their treatment by HMRC, and in the relationship between inquiries into a return under Section 9A of the 1970 Act and inquiries into a claim outside a return under Schedule 1A.